Magandang gabi. Ako po si Trixie Cruz-Angeles and this is Luminous Live. I apologize if it had taken some time, but let's do an audio check first because we have a lot to talk about and I'm not sure if 1 hour is going to cover this. At any rate, let me just double check. Okay, audio check 1, 2, 3. How are we doing with our audio?
Check 1, 2, 3.
All right.
Doing with our audio.
All right, good evening to everybody who is here. Mahaba yung portion ni Justice Leonen, so let's leave that for the last. Let's start with Justice Mundo's interpellation primarily, which centered on Attorney Jokno. He had two major points dito sa oral argument. Sabi niya, first, Justice Mundo asks if, ang position kasi dito ni Attorney Jokno is that Section 4 of the Anti-Terrorism Law is void for vagueness because it punishes intent even if the act itself is legal. Okay? So this was also dealt with by Justice Leonen. So let's deal with that argument based on the on the questioning by the two justices, Justices Hesmundo and Justice Leonen. Justice Hesmundo asked Attorney Jokno, why is the Section 4 void for vagueness? Attorney Jokno says the ATL punishes even non-criminal acts based only on the intent of that act. So sinasabi niya, kahit legal, kunwari nagrarally sila, pero so legal naman ng rally, pero ang intention nila ay mag-cause ng damage, naiiwan sa discretion ng pulis to determine kung nag-violate nga sila ng Anti-Terrorism Act. Ang sinasabi ni Justice Hesmundo, tinanong niya, ano ba ang basihan sa ating batas para masabi na may intent? Ang sagot, of course, which Justice Hesmundo had to provide is, para masabing may intent ang isang tao, binabase yon sa pagbabasa ng overt acts. Okay? So alam mo na masama ang intensyon ng isang tao dahil nakikita mo na sa galaw niya na yung masama yung intensyon niya. Di ba? So, kunwari, rally, legal nga ang rally, pero the moment na nagrarally ka pero hinampas mo yung placard at somebody else, then that is your overt act. Ang mas classic na example dito is a coffee shop. Ito yung mga umiikot kasi sa social media. Sabi ng ilang mga kabataan, mga woke daw, punta tayo sa coffee shop, pwede tayong maaresto. Even if we're just sitting, we're sipping coffee, pero supposedly we talk about overthrowing the government or some illegal act or killing somebody, even if we don't do anything wrong, pwede daw silang arestohin. Hindi totoo yon. Kasi if you're sipping coffee in a coffee shop and then with every intention of killing somebody but you do not make any move to kill anybody, then that is not punishable. So yung pagpupulong, pagrarally o yung ibang mga krimen na ganon, ang sinasabi ni Justice Jokno, ang intensyon binabase sa overt act. Ngayon, ang sinasabi naman ni Justice Leonen dito kay Attorney Jokno dun sa kanyang argumento tungkol dito sa innocent act daw pero intention ng pinuparusahan. Sabi ni Justice Jokno, no, that's not true because the law defined that it is a crime to commit this particular act with this particular intention. So, krimen na siya. Hindi mo pwedeng sabihin this is an innocent act, this is already a crime kasi nakalagay sa anti-terrorism law na krimen siya. Simple, Mas complicated na ngayon yung ibang another simple argument. Ang importante din yung sinasabi ni Justice Hernando na karamihan daw ng mga nag-question dito at kaya siya nagtatanong pero hindi pa siya natatapos. Nagtatanong siya, bakit ang lumalabas dito, in spite of all the safeguards that were put into the anti-terrorism law, ang pinaiikot ay takot. Bakit puro takot ang pinag-uusapan tungkol dito sa anti-terrorism law? Samantalang ang intention nito ay magprotekta ng tao. Okay, let's go to the arguments now of Justice Leonen. Doon kay Attorney Latif, ang questioning ni Justice Leonen is primarily on intention. So, sabi niya, nag-umpisa siya with a definition of terms. Pinagkaiba niya kung ano yung extremism at saka terrorism. Ang extremism, syempre, is a matter of belief. Pwede kang extreme Marxist. Pwede kang fundamental religion, whatever the religion is. Pwede kang maging ultra-Catholic. At any rate, extremist. Maraming klaseng Marxist, maraming klaseng Katoliko, maraming klaseng etc. So, but it is a belief. At, syempre, hindi pinaparusahan ang isang paniniwala. Terrorism, sabi niya, is the method. So, extremism is the belief, terrorism is the method. And terrorism is what is punishable. So, nakikita niya na, ginamit niya dito, maganda dito, yung example ni General Parlade. Sabi niya, and ito, significant ito, tatandaan ninyo ito, in the defense of General Parlade. Number 1, pinaparusahan natin, si General Parlade, alam natin, is staunchly anti-communist. Tapos, sinasabi niya, na-offend siya dun sa speech ng mga komunista. Pero, sinasabi ng mga komunista at ng mga iba, na yung salita nila, kahit in support of terrorists, in support lang sinasabi nila, protected speech yun. Ngayon, pag nagagalit si General Parlade at sinasabi niya, kayo, mga terrorist front organizations, bakit yung speech ni General Parlade ay hindi protected speech? Kikita niyo na yung difference? Yung speech ng, ni, let's say, Sara Elago, sinasabi na protected speech yan, kahit sinasabi lang niya is, or speech ni Teddy Casino, ay sinasabi nilang, suportado nila yung mga kasamahan nila na namundok, kasi suportado nila yung paninindigan ng mga yon. Sasabihin nila, hindi nyo kami pwedeng i-terrorist tag, kasi protected speech yan. Pero, pag si General Parlade naman ang nagsasalita, at sinasabi niya, nakaka-offend yung sinasabi ninyo. Mga communist terrorist front organizations kayo. Bakit yon? Hindi ba siya protected speech din? That was a very interesting sidelight that Justice Leonen had pointed out. So, sabi niya, bakit ngayon tinayo ang anti-terrorism law? Base dun sa pag-uusap nila ni Attorney Latif, yung hukuman should take care kasi bakit daw tayo nagkaroon ng anti-terrorism law? Bukod sa pinapunish natin yung terrorism para to prevent it from happening dito, ay pinaparusahan ito o gumawa tayo ng batas kasi may obligasyon tayo sa United Nations Security Council. Ngayon, naalala ni Justice Leonen, ang sabi nga niya is, oh yes, I remember that Attorney Evelyn Ursua mentioned na hindi naman siya punishable kahit sabihin na pa natin na labag siya dun sa direktiba ng UN Security Council. Alam natin na hindi totoo yon kasi sabi ni Justice Leonen, no, it is very clear in the UN Charter that the United Nations Security Council can impose sanctions. So, meron mga embargoes and all that the UN Security Council can impose on countries when they do not fulfill their international obligations. Okay, next. Sabi niya, the other is that, ang isa pa niyang point is, pwede bang sabihin ng Supreme Court dito sa Kongreso, hindi maganda yung anti-terrorism, no? Balik na lang kayo dun sa Human Security Act. Sabi ni Attorney Latif, of course not. And that is true. Kasi iba-iba ang mga trabaho ng branches of government. The executive, of course, executes and enforces the law. The Congress makes the laws. The Supreme Court determines, interprets those laws, or adjudicates actual cases and controversies. So, hindi pwede rin sabihin ng hukuman, uy, Congress, balik na lang kayo dun sa Human Security Act, pangit ito. They can't do that. Because nasa discretion ng Kongreso na palitan yung lumang Human Security Act at ilagay nila itong panibagong anti-terrorism law. Sabi ni Justice Leonen, we cannot substitute our judgments for the judgment or the discretion of Congress. Hindi naman din sila law enforcers. So wala din ang hukuman, wala din sila sa posisyon magsabi dito sa mga pulis, wala din sila sa posisyon para sabihin na ganito ang gagawin ng pulis o ganito mag-exercise ng discretion ng mga pulis pag ine-enforce nila itong batas na ito. They have no personal knowledge of how the police are going to enforce the law, kung kaya't nagiging parang predictive lang to. Speculate lang ito. Unless there is an actual case that tells us how the police are going to execute this law, then hindi natin pwede silang pangunahan. Okay. So, okay. Pag sinasabi kasi ang sinasabi kasi ni Attorney Latif is that yung sa Human Security Act, enough na yon para masagot lahat ng iba. Tapos sabi niya, in fact, may Human Security Act pero nanalo naman daw sa Marawi. I think that was his line of argument. Pero ang sinasabi ni Justice Leonen, parang it's the other way around. Really, we could have prevented Marawi if we had this anti-terrorism law. He didn't say that actually, pero that was what you can glean from the questioning. Okay. Speech is protected, sabi ni, so taking from the example of General Parlade, ang sinasabi ni Justice Leonen, protected ang speech. And there are many kinds of speech. So merong speech na action siya, pero expression pa rin yung action na yon. Halimbawa, merong mga iba na gusto nila sa ibang mga bansa, like sa US, ang pagsusunog ng American flag is an expression of dissent. Dito sa Pilipinas kasi bawal yon. Pero expression pa rin yung act na yon. So ang tinatawag na yun, acts which are expressive, ay pinoprotektahan din ng ating saligang batas as the freedom of speech, as an expression that is protected by the Constitution. So, ang ginagawa nyo natin ng batas is you curtail the, nawala yung notes ko. You curtail the ability, speech is protected, but conduct can be expressive, such as the burning of a flag. But certainly, violence cannot be protected speech. Diba? So, kung kunwari, nag-interpretative dance ka, pero yung interpretative dance din meron kang protest or something like that, okay lang yon. That's still speech. Even if it is an action, it is speech. But if your action, expressive as it is, causes violence on somebody else, at sinasabi mong, as a political statement, I am going to kill this person. Then that is already violence, and that is no longer protected speech. Diba? But you do not curtail speech. Bali, pinoprotektahan natin ng speech, hindi natin pinapayagan na pagbawalan ang pagsasalita ng tao, pero because you don't want kumbaga, nakaprescribe sa ating saligang batas yung against curtailment of the freedom of speech. Pero you can stop a violent act. So, kailangan overt act ang pinapunish ng ating Section 4 sa Anti-Terrorism Law. Okay? So, ang sinasabi nga, medyo extreme din si Justice Leonen, sinasabi niya, extremism is different from terrorism and extremism should be allowed because under freedom of expression, but by itself is not a value unless there is a philosophy behind it. So, yung expression mo, kailangan merong dahilan para doon. Sabi niya, even a false idea, and this is something we have to remember, even a false idea or an opinion is important because it enables those in the status quo to refute the idea, and therefore, the test of the truth is tested in the marketplace. Ibig sabihin, sa maraming ideas, magko-compete yung mga ideas natin. Hindi mo pinipigil yung pag-express ng mga ideas na yon kasi mas maganda kapag natetest yung mga ideas na yan pagka nagkakatunggalian, may advocacy, may exchange, merong opposing views and all that. And the views and your opinions and your stand can be tested by interacting with other ideas. Okay. So, yun yung kay Attorney Latif. Si Justice Leonen with Attorney Colmenares was also short, pero eto yung maganda. First of all, it was a lesson on how not to conduct an oral argument. Unang-una, si Attorney Colmenares was insisting on giving a speech or insisting on giving his points. The purpose kasi of an oral argument is for the justices to be clarified on what your position is. So, si Justice Leonen, iba yung kanya. Socratic method ang tawag doon. Para siyang recitation. You answer and you answer kasi yung flow ng kanyang speech will depend on your answer. Okay? So, sabi niya, ang argument ni Attorney Colmenares is on the 14-day period. So, meron ding argument si Attorney Jokno on this one. So, i-compare lang natin because iisa lang talaga yung argument nila. Ang sinasabi nila is the standard for detention is set in the Commander-in-Chief provisions doon sa ating saligang batas. Okay, this is important. Ang sinasite nila Attorney Colmenares at Attorney Jokno ay iisa. Ang sabi nila, ang worst case scenario o most violent incidents happen during this period at that is the reason why the Commander-in-Chief declares martial law. So, nagdideklara ng martial law kasi sobrang gulo na. So, kung ganun nakagulo, then tapos 3 days ang inaalaw lang ng detention period nang hindi charge ang isang suspect, then dapat yun yung susundan ng lahat. Si Justice Hismundo, simple lang yung kanyang pagtutunggali kay Attorney Jokno. Sabi niya, anong nakalagay dyan sa provision sa saligang batas? Hindi ba rebellion, invasion, at saka suspension of the writ of habeas corpus lang pinapayagan yung 3-day period na yan? Sabi ni Attorney Jokno, well, yes, the strict reading of the law, pero that's not daw their point. Ang point nila is, hindi, ito kasi yung pinakagrabe. Wala nang ibang standard. Ang sinasabi ni Justice Hismundo, hindi, if you're going to cite that, you take the whole provision. It only applies to those 3 instances. Okay? Si Attorney Colmenares naman, ang sinasabi niya is that let me see. Yung nagiging arbitrary, it's arbitrary detention kasi nga dapat 3 days lang. Pero wala siyang, aside from the citation of the Commander-in-Chief provisions, hindi niya, wala siyang ibang basehan para dun sa standard na yon. So, ang ginawa ni Justice Leonen, inilakad siya. Sabi niya, kapag na-detain ka for 14 days, yung 14-day period, available ba ang writ of habeas corpus? So, kasi nakalagay doon is allowed, legal ang detention for 14 days. Pwede ba ang habeas corpus? Ang sinasabi ni Attorney Colmenares, hindi. Pero are the circumstances the same? Ang habeas corpus is to prevent yung i-disappear ka at saka to prevent yung itatago ka and all that and that you're being detained beyond a reasonable period. Ang ginawa dito is binago yung reasonable period from a maximum of 3 days under the Human Security Act to 14 days under the Anti-Terrorism Law. Okay, ang argument naman nila sa surveillance, yun ang sinasabi ni Justice Leonen na there are 2 instances when you get a warrant. One is when the crime has been committed and you're looking for evidence, and the other is when you are trying to prevent the crime from happening. Okay? So, and in both cases, justified siya. In fact, dun sa anti-terrorism law, kaya nga may ganyan na period, kaya nga may ganyan na surveillance is because you are out there to prevent a crime from happening. Okay? So, sabi niya kay Attorney Colmenares, you have to discuss this in your memorandum. Okay. Next. Yung kay Attorney Jokno, mas deadly. Kasi, ang sinasabi niya is, dun sa Section 9, yung inciting to terrorism. Ang sinasabi ni na Attorney Jokno is that this violates the freedom of speech. Diba? So, ang sinasabi ni Attorney Jokno, yung incitement, dapat hindi yan pinaparusahan kasi nga it violates the freedom of speech. So, ang sabi ni Attorney Leonen, wait, hindi, let's go through when speech can be punishable. Kasi bawal sa atin nagre-restrain ng speech, pero pwede mong i-punish ang speech after it has been uttered. So, kailan kunwari, ano yung exceptions to constitutionally protected speech. Kung inciting ka na, naghihikayat ka na mag-commit ng isang krimen. Tapos, hindi lang yung paghihikayat. Kailangan may imminent lawless action. Ibig sabihin, may mangyayaring act. Somebody is going to commit an act at inuudyok mo to commit that act. And yung pag-uudyok mo is likely to produce such an action. So, tatlong elemento yon. Yung incitement, yung speech, yung may yung circumstances so that alam mo na posibleng mangyari ito. Tapos dahil sa pananalita mo, posibleng gawin 'yon nung taong inuudyukan nyo. So, sabi niya, ang UN pinoint out niya kay Attorney Jokno na there is whenever there is advocacy, ang advocacy protected yan. So, kunwari, kahit sabihin pa natin, komunista ka, naniniwala ka dun sa common property and all of that, protected yung speech ng pagtuturo, halimbawa ng komunismo. Pero he pointed out the difference. Kung ikaw, nagtuturo ka doon sa sa mga terorista, paano gumawa ng bomba, protected speech ba yung pagtuturo na yon? Siyempre, hindi. Pero kung nasa university ka at ang pinag-uusapan, academic discussion of what is rebellion, what is communism, how people commit communism, how people can be incited to communism, but it is a classroom setting. Now, do you see the difference? The classroom setting, where you're merely learning about communism as opposed to other forms of a government or economy or economics or philosophy, and the difference between the teacher who is teaching how to make a bomb. Ano dyan ang poprotektahan ninyo? Obviously, the classroom setting is protected speech, pero the terrorist setting is not protected speech. Diba? So, ibig sabihin, meron ng jurisprudence na nag-establish kung anong speech ang maaaring ipunish. And one of that is that speech nga can imminently cause damage. Hindi naman sinasabi sa Section 4 na sa Section 9 na just that incitement, because you're going to take into consideration yung jurisprudence, yung mga sinabi na ng hukuman tungkol dun sa mga klaseng pagsasalita na napaparusahan. Yan. Ang tapos yun na nga, sinabi ni Attorney Jokno, kasi dito sa Section 4, intention lang, punishable na. And then, sabi ni Attorney Leonen, hindi. The Section 4 defined a new crime, which is committing what would otherwise be a legal act, coupled with intent, and that is now a new crime. They're not punishing the innocent act. You're punishing the innocent act plus intent, and that constitutes a new crime. So, almost done. Baka naiinip na kayo. Okay? Because, ayun. Attorney Molo also faced Justice Leonen, and he asked about the chilling effect. Ito yung masaya. Doon sa sinasabi, tinanong ni Justice Leonen, si Justice Carpio ba, former Justice Carpio ba, natakot siya? Tumigil ba siya sa pag-advokasya niya tungkol sa West Philippine Sea? Hindi daw. Natakot ba daw si Teddy Te? Puro mga teacher ko to. Si Sir Teddy Te, si Ma'am Evelyn Orsua, ganyan. Sila ba natakot dahil sa anti-terrorism law? Hindi. Doon sa UP, DND, pag tanggal ng accord, di ba? Andun yung mga yon, nagmamakibaka sila doon. Ano yung classic stance ng UP? Giting at tapang, di ba? Ibig sabihin, kapag ino-oppress, tinutunggali, sinasalungat ang mga taga-UP, lalo silang tumatapang. Okay? So, may chilling effect ba daw? Tumigil ba yung mga tao sa kakasalita? Tumigil ba yung kakarali? So, sabi ni Atty. Molo, hindi. Pero, it makes you stop and think about your actions before you actually commit the action. Sure, everybody's brave, pero yun na yung sinasabi ni Leonen. So now, how are you going to define this chilling effect? Di ba ang chilling effect ay subjective yan. Hindi yan everybody suddenly decides they're not going to do this, or they're not going to talk, they're not going to do anything. As long as you comply with the terms of the law, how can you say that this is now a chilling effect? It isn't daw, a chilling effect is not a matter of fact, it is subjective. So how can you claim that there is a chilling effect if you have no example of that chilling effect? Uy, Tapos tayo. Okay naman pala. So, actually, medyo maikli-ikli lang yun. Let's look at your questions now. Ay! Okay. Don't forget to like, share, and subscribe. Okay, thank you kay Sir Roel Costello. Ay, dami na palang ano. Magandang gabi sa lahat. Sorry, hindi ko kayo maisa-isa. Sabi ni Pinay Paparazzi, hindi justice joke, no? Oo, naalam ko naman yung mali ko. You don't need to point it out anymore. Isang highlight dun kanina yung distinction of public safety and public health. Dahil pinipilit ni Jokno na pwede daw tawaging terrorism ang paghahawa ng COVID. That's not what he was saying. He was saying was that the police might interpret a public gathering as falling under Section 4. Which of course, nasan yung overt act doon? 'Di ba? So, ang sinasabi niya is kasi may damage na ano. Oh yeah, but what is the overt act? Did you gather para mahawa ang mga tao? Was there an intent to do that? 'Di ba? Guys, stop with the when I make a mistake that is easily correctable, please don't belabor the point because it's distracting. Yung isa, 5,000 ang danyos ng Human Security Act ang hinahanap. Ito yung si Attorney Latif. Attorney Latif was saying na mas maiging Human Security Act. Attorney Latif was saying that we should revert to the Human Security Act, or we should the anti-terrorism law is insufficient kasi the anti-terrorism law is insufficient kasi yung civil damages daw hindi na-address. Sabi ng Justice, what do you mean? Of course, you can still go to the courts and ask for civil damages and file your civil case. Ang sabi ni Attorney Latif, oo, pero sa civil case, magkano lang? Doon sa Human Security Act, na-set na nila at 500,000. So, nade-deprive yung mga tao, dapat ibalik daw doon sa 500,000. Okay. Magandang point daw, sabi ni Bernalisa Hortelian, no, preventive talaga ang purpose ng ATL. That's one of the purposes. One is to punish, the other is to prevent. Yung preventive dyan, of course, yung surveillance, pwede kang mag-conduct ng surveillance, which can be also electronic surveillance. And then the other is, you can also use the surveillance methods to find evidence of the commission of the crime para ma-prosecute, prosecutorial. Di daw tugma sa narrative nila kaya thumbs down. May nag-thumbs down? That's well, wag niyo nang pansinin. Wala bang parusa doon sa pagsuhol ng mga aita na pinilit lang sila? Well, if the lawyers did that, then there could be grounds for disciplinary action. But let's get the facts first. Let's find out what really happened here. We'll talk about that later on. Let's see your questions on the oral argument first. Nagtaka lang kami sa live audio ng SMNI kanina dahil picture ni Justice Karandang ang pinakita pero boses ni Justice Leonen. Ay, grabe. Sabi ni Attorney No Case, Chell was burned by the next CJ. Si Justice Esmundo. I think it might be Justice Perlas Bernabe first. Hirap din ng mga abogado ng kabila nakikipag-debate sa judge. Tama ang sinasabi ni Brandon. Kasi sa US, pag haharap ka sa Korte Suprema, bago pang mangyari yon, merong parang rehearsal. Kung first time ninyo, then meron parang rehearsal, you're given pointers. You address the justices as your honors, you don't interrupt them, you do this, you do that. So may ganon. You're informed about the rules. In the meantime, thank you kay Juvis Ventures at saka kay sino isa? Si Roel Costello sa super chat. Yung okay, so what not to do in oral argument, na pagsabihan tuloy ni Justice Leonen si Attorney Colmenares, kasi the time for arguing has passed. Yun na yung binasa nila, yun na yung sinubmit nila sa petition nila, at kung sa tingin nila may kakulangan dahil nga sa basis doon sa mga pagtatanong ng mga mahistrado, sa tingin mo, hindi mo na ilagay yan sa mga pleadings mo. Ngayon, alam mo na kung anong ilalagay mo. Kung hindi nila hinihingi yung sagot mo o hindi nila sinasabi, argue this, huwag mong pipilitin. So, they should always be listening. Tinuturo yan kasi sa UP, sa aming recitation, kapag sumasagot ka ng hindi sapul dun sa tanong, pagsasabihan ka talaga ng mga professors. So, they should have carried that into the oral argument kanina. Pero para sa akin, medyo maano yan, na medyo mababaw yan. May joke pa nga kanina, di ba? Si Justice Leonen, na sinasabi niya, so alam ninyo kung anong gagawin ng mga pulis? Ano kayo, Manila Times? Para alam ninyo what's going to happen next? Alam ninyo kung anong magiging resolution ng, alam ninyo na pagka umakyat kayo on habeas corpus dito sa Korte Suprema, alam niyo na kung anong magiging outcome? Ano kayo, Manila Times? Di ba? The impression I got, sabi ni Quantum Gear, from Chell's statement, was that they were trying to blur the meanings just to get their point across to the justices. Well, hindi. Ako, for instance, normally, I like the way Attorney Jokno argues kasi he answers the questions and he gets his point across. Pero minsan, nag-i-interrupt siya. Ini-interrupt niya si Justice Mundo. Tapos pinipilit lang nila, that is our position. Imbis na i-argue niya, imbis na sabihin niya, well, you're correct, Your Honor, however, ganito, walang ganon eh. So, I was, kumbaga, I did not like it. But that's just me. That's just my hampas lupa opinion. Okay. Sabi ni Gamaliel Reforma, Justices Mundo, so anong problema mo? Is the amount? What about Article 35 of the Civil Code where you can file an independent civil action? Yes, that's usually either for tort or for criminal act, pero ihihiwalay mo dun sa criminal case. Okay. Thank you kay John Paul Padonia. Sabi ni Kilay Problems, sa 100 na sinabing tama ni attorney, 1 or 2 mistakes niya ang napili na i-comment. Hey, anyway, thanks for breaking this issue down kasi pulugaw ang brains ko when I tried listening to it. Actually, medyo nag-geek out ako kanina. Merong napikon nga si Justice Mundo. Medyo napikon nga si Justice Mundo kay Attorney Joke, no? Kasi, di ba, nag-i-interrupt siya, tsaka nagpipilit lang siya. So that's not how to argue. You don't just dig in and say, hindi, ito yung point namin, ito lang gusto namin. You're there for 2 things. To clarify the issues and the facts for the justices, and 2, to convince them. Ngayon, kung hindi na sila nasa punto that they're asking you to convince them, you will do that through your writing. Diba? Okay, ano daw sabi ni Judge Hinojales? What is the chilling effect? Ang chilling effect ay kapag meron kang ginawa na rule or batas or action that leads to a policy that prevents you from speaking, that restrains your speech. Okay? Bawal kasi sa atin ang tinatawag na prior restraint. Ang prior restraint is you're making a rule shutting up people. You can make a rule that punishes speech that can cause damage, but you don't punish a person or you don't prevent a person from talking. So yung chilling effect is the effect is that you're being prevented from speech. Diba? Sabi ni, nawala. Saturn Feji, piko na si Leonen sa Manila Times. Ang galing kasi ng insider, yung ika-nth na Associate Justice. Well, I think by making a joke, at least Justice Leonen can now roll with the punches. Diba? Sabi ni Ma'am Christina, when one justice, I think it was the Chief Justice, asked Chell if he would represent yung dalawang Aita, and Attorney Chell said, I'll have to confer with my clients. Nag-flashback ako sa fisherman, ang bad ko. And I'm glad to see that he's being careful now. Sabi ni Brandon Legaspi, I thank you kay John Paul Padonia. Si Attorney Molo, pinipilit na may chilling effect ng ATL, sinasabi make a distinction na pagka Court of Appeals, Sandigan Bayan at saka Supreme Court, they're justices. Below that, they're judges. Sinasabi ng justices na walang ipipilit pa rin niya. Yun, ipipilit pa rin niya. So, Yeah, well, what do the, good evening. Ito, kay Ray the Great. Surveillance pa lang takot na sila. Take note, person of interest pa lang ayaw na nila ng chilling effect na sa kanila is not that correct. Sabi ni FC Talon MD, nagpaparinig ba si Leonen kay Solgen kanina about sa Coaranto? Coaranto. Not sure. Alexander Ahad says, hi, good evening, watching and listening from Bukidnon. Hi kay Ma'am Joan. What will happen if a provision in the ATL is proven to be unconstitutional? Well, if there is a separability clause in the anti-terrorism law, meaning you can strike out one provision and the rest of the provisions will remain in effect. And then, kung sa tingin natin or sa tingin ng Kongreso ay kailangan gumawa sila ng additional na batas para amyendahan ito, then that's what they're going to do. But, you can't trust Congress to work on that right away. Uubusin po ba lahat ng Associate Justice magtanong pagkatapos isasalang si Solgen? I'm not sure, but that is possible kasi the respondent comes later. So, not all the justices usually want to ask questions. Merong iba kasi one or two lang. So, it depends really on how, usually maraming tanong kung malabo yung petition. Kasi the purpose here is to clarify. Sabi ni Checks and Lines, are they against ATL on principle or just to show that they are contrary? Rhetorical, sort of. I don't think that is very clear to me. But just to give you an example, some of the petitioners against the Human Security Act are also against the anti-terrorism law. Sino kaya yung mga lawyers na pinaringgan ni CJ? Well, we know that. Okay, now let's go back to the CJ. Ano nangyari at the start of oral argument? May nag-manifestation yung Solicitor General that they now have an affidavit on the two petitioners who wanted to be last-minute petitioners dito sa Coaranto. So dito sa Declaration of Unconstitutionality of the Anti-Terrorism Law. So, saying na yung mga AITA were not real parties, pinapirma lang daw sila ng reklamo, may mga pumunta daw doon na abogado na nagpakilala. Say hi, Yoshi. Nako. Okay. May nagpakilala daw ng mga abogado at nagpapirma nung petition and that they weren't really filing that petition. So, medyo nag-react si Attorney Colmenares, pero sabi ni Justice, sabi ni Chief Justice, medyo moot na yan kasi dinismiss na namin. Sinabi ng Korte Suprema, hindi nila tatanggapin yung last-minute filing ng petition na yon, pero hindi nila sinabi yung dahilan. Ngayon, I can speculate on what the reason is kasi nandun yata sila sa RTC, dinidinig naman yung kaso doon. So, kailangan i-establish muna ang facts kasi the Supreme Court is not a trier of facts. So, yung facts kailangan i-establish pa sa RTC. In the meantime, yun nga, may pasabog si Solgen. Medyo na muffle lang yung pasabog niya kasi nga, hindi naman tinanggap ng Korte Suprema yung petition to begin with. So, what the Solgen can do is he can have the case, the petition or the affidavits noted in the RTC. Okay? Ay, si Yoshi talaga. So, hi, thank you to Julius Ortea. Sige, let me see if the dog wants out. Okay, naririnig niyo si Yoshi. Okay, from the PNA, sabi ni Noel Sams, the Supreme Court junks the two ITA's petition for intervention in the suits against the anti-terrorism. Yes, that's what we're talking about. Si Jokno pati yung COVID kasali sa opening remarks. Sabi sunod na sunog petitioner lawyers eh. Okay, but let's clarify. The reason for an oral argument is for the justices to understand fully the side of both parties, to understand what provisions they are seeking to declare unconstitutional and what your grounds are. Okay? So, what their grounds are. And then, pag sa tingin nila kulang, like what Justice Leonen is doing, sasabihin niya na, oh, you have to discuss this in your memoranda. Okay? Sabi ni My Munchkin 31, maganda yung starting ni Leonen kanina kasi na-cite lahat ng terrorist groups besides the NPA. Parang pinupoint out niya na hindi lang NPA ang terorista. That is correct. Amaya says, nakakatuwa naman pakinggan yung arguments, pati yung COVID. Oh yeah. Are they against the ATL? Yes, we read that na. Sino kaya yung mga lawyers na pinaparinggan ni CJ? Well, the CJ also pointed out, he reminded the lawyers to stop arguing the points or the merits of their petition when they are being interviewed both on social media and in traditional media. And sabi niya hindi na daw niya babanggitin ng pangalan. But we know of 2 interviews that we actually watched kay Attorney Chel Jokno and Attorney Nery Colmenares. But the justices, or at least Chief Justice, was only warning them. Sabi niya, to not discuss the petition or the merits of your petition because this might affect the outcome of the case. Okay. So, I think that was a fair statement. And wala naman siyang mga paratang na iko-contempt ko kayo o padidisbar ko kayo. But that is violation of the sub judice rule. Thank you kay Julius Ortega at saka kay Kat Slim. Sabi ni Ma'am Pinay, sorry for the correction. I wasn't able to follow the proceedings, so I listened intently to your discourse in my flow to understand where thrown by the mistake. I didn't mean to be mean po. Yes, pero can we refrain from from yung mga bababaw na things muna. And then let's get all of this out of the way. And then later on, you can tell me that. Kasi what's important for me is while your attention is still, while I can still catch your attention to get all of the important points in. Kasi as we know, even on social media, there is a time span. Most people have an attention span of only about 15 minutes. That's why I try to get in as many important points as possible within the first 10 to 15 minutes. And then I discuss your questions later on. So if the first questions that come out are the mababa ones, then we don't have time to discuss the important ones. Baka hindi to marinig, and that is the purpose for my calling that out. But don't worry, I'm not angry. It's just that it's easier so that when we discuss here, then we get all the important points in right away. Sabi ni Ma'am Duel Sams, binayaran lang daw ng 1,000. Yes, according to the manifestation made, 1,000 ang binigay. Dun sa dalawang item, maghati na lang daw sila. And then there was a portion where they were allegedly saying, allegedly, na sabi pa nga daw sa kanya, ayan kita mo, layo-layo na yung lawyer dumating pa dito, layo-layo ng pinanggalingan, galing pang Manila yan, pirmahan mo na lang. So, this is a way of pressuring them, di ba, to participate in the petition. Sabi ni Jumong, masubjudice po ba si Chel at Colmy pag nagsalita pa uli sa SOCMED? Well, it is possible that they will be admonished by the Supreme Court. Kasi as much as possible, medyo maano din yun the Supreme Court is calling them out for their behavior, pero they also don't want to be distracted. You don't want them concentrating on yung mga ginagawa nilang ganon, but rather to concentrate on what is at hand. And what is at hand is to declare whether or not the ATL is constitutional. Yes, sabi ni Kat Slim, parang sailing super chat. I'm sure that's very much appreciated. Actually, it is. Thank you kay Ma'am Kat Slim at kay Julius Ortega and everybody else, Saturn Feji, John Paul Padonia, Juvis Ventures, and Joel Costello. Uy, maraming salamat sa inyo, ha. Yes, this is very much appreciated. Sabi ni Gamaliel the Forma, I wish magturo ka po sa law school namin kahit Davao kami pero online class naman. I don't think they'll take me. That's why we do this nga kasi is that the law has to be demystified for the general public so that they can participate in it. Okay. Tinatanong ni Judge Inojares, why did Justice Alex cite Australia's definition of terrorism while Justice Leonen already said that in the UN, na definition of terrorism is based on domestic something. Okay. the UN Security Council also leaves up to the individual. No, actually, it was the EU Parliament that recommends that each of the jurisdictions, each of the states, can also further define terrorism within their own jurisdiction. But there are general principles. The most basic principle of terrorism is, of course, an act that causes widespread fear or intends to coerce governments or populations to do something that either is illegal or just simply against their will. So, yun yung and in fact what you're defining it as an effect, 'di ba? But Justice Alex Sismundo was using the Australia law to show that in our other jurisdictions, this is what they do. 'Di ba? Like an example, how else are you going to punish the intention to commit terrorism, 'di ba? Sabi ni BJ Cans, ano po yung Section 4 na sinasabing tanggalin para ma-save ang ATL definition? Section 4 is the definition of terrorism. So once you take out kasi Section 4, you take out the whole terrorism law. That's the heart of it. If the challenge on ATL is like an argument of those more beautiful, of who is more beautiful, Lucy Torres or Jover, sabi ni Ophirian Shemites. Wala akong masabi doon. Pero I want to, to just clarify what the intention here is. The justices aren't going to base it on how famous you are or how popular the lawyers are or how popular the case is. They're going to decide this based on what is in our Constitution or what our Constitution intended, diba? And the purpose here is to serve the ends of justice. It's not to uphold the beliefs of anybody, but to make sure that there is peace and order. And it seems that there is no question that we have to have an anti-terrorism law. One, to comply with our international obligations, and two, to actually prevent and prosecute terrorism. And as pointed out by Justice Leonen, there's only been one prosecution under the Human Security Act. So, tinatanong ni Madam, Christina, kung duress po ba yung nangyari sa mga ITAs? Well, it is sufficient for them to controvert that they willingly signed the petition. So, what they're saying is that wasn't us. Whether it was duress or not, it's not even, how do you call this? To not even be considered because they're already refuting their own affidavit. What about po kay Congressman Lagman being the incumbent congressman? I answered this already. Was not allowed to represent as counsel for the petitioner. No. Although the Constitution says that, the Supreme Court already defined that the congressmen and senators can appear on behalf of their chambers, the Senate or the House, or as individual congressmen when any law affects them. And as we can see, the party list representatives feel that they are going to be damaged by the anti-terrorism law. So that is why Congressman Lagman is there. And that is why even the justices are not questioning his own standing to sue. Hope you can discuss in Karambola these issues on LTO. I think we discussed on Tambayan kanina, the car seat law. So, hindi po ba nakakasawa, sabi ni Manuel Cartagena, hindi po nakakasawa. Si Attorney Trix from Karambola, Tambayan at live broadcast, food for the brain. Sometimes I worry, pero I will do the stuff more often kapag may mga pressing na controversies such as this one. Sabi ni Ryan Padernal, kaya pala ever since, piling-pili lang ang interview ng Solgen. Yes, and usually when a case is done. What about kay, sa October 8 daw, birthday ni Adrian Abuhandan, pupunta daw siya sa DWIC. Of course. Ano pong section? Okay, parang parang nabasa ko na ba lahat? Ganun lang ka-konti questions niya. Maganda daw audio, sabi ni Mark C. Kasi minsan daw mahina yung audio. Minsan kasi hindi ko nasasaksak na maigi yung mic. Watching from Abu Dhabi, si Eric Rivera. Magandang gabi kay Paul Jimenez. Watching from Tacloban later. Yay, Tacloban is represented. Maupay na gabi. Can you also convince Mayor Sara to govern us come 2022? I'm not sure if she will listen to me. Of course, we're supportive of Mayor Sara. But if she's going to make a decision, it will be based on her own judgment. I don't think she can be convinced by kayo naman, hampas lupa lang ako. But, if ever, we want her to know that we are supportive of her. Isang highlight kanina yung distinction of public safety. Oh yeah, we read this. Good evening from Alcobar, KSA, si Romiel Dalay. Good evening kay Dolandro. Leonor Gabawan says, winner yung translation example ni Justice. Nangamote ang sagot. Yeah. Audio and video are clear. Thank you. Good evening kay Sir Bobby, kay Rick Comidoy, who's watching from UAE, Jamie Houston, Calvary Kane, Raymond G, Aki Celoso, and hi Ma'am Pinay Paparazzi, of course. Good evening kay Cheslao, Yana the Mongrel, FC Talon, Lubinso, Christine A, Gitville, My Munchkin 31, William Games, Dulce Isi. Okay, so let me see if you have additional questions. We appreciate daw yung effort, sabi ni Cite and Fenji, to make the law palatable sa mga common tao, tulad namin. Yes, from one hampas lupa to common tao. Sakali mo basura ang mga petitions kontra sa ATL, maaari ba silang umapila sa CA or else idaan sa arbitration? No po. The Supreme Court is the court of last resort. So the Court of Appeals is lower than the Supreme Court. So you don't go lower. You always go higher. The best that they can do is file a motion for reconsideration. And if that doesn't work, then the law is there. They'll just have to work on getting a repealing law from Congress, if they can. Sabi ni Elmer Bernardino, now I understand why you put Justice Leonen in high regard. His mind is both beautiful and terrifying. Even if you come prepared, it is not enough. Yes, that's true. That's why even before he became very, very controversial, I would tell people that whatever wins I made in the trial courts before, you can always credit or blame that on Justice Leonen, because he was my teacher in criminal procedure and special procedures. Yun, sabi ni Kuya JPS Channel, wala po bang Muslim groups na nagpetition din kontra sa ATL law? I think those were represented by Attorney Latif. Ano po next step? After these oral arguments, there will be submission of memoranda, and if necessary, the justices will ask the parties to comment on each memoranda, or they can make a decision based just on the memoranda. Or even before that, the justices can take into consideration the oral arguments, and they can also possibly dismiss, either based on one, lack of standing to sue, or lack of merit. Anong tingin niyo malaking leverage o maging punto ni Chel Jokno about the anti-terrorism law? His primary argument was on Section 4 and its void for vagueness rule, and his reliance on the void for vagueness rule. And the second is the extent. Hi, it's the cat. It's Hi. Oh my goodness. Okay, Belial. The second argument was against the 14-day detention period. Pero if you're asking ano yung malaking puntos, I'm not sure. They haven't even argued yet, and the justices have not asked any questions on the seemingly retroactivity of the law, or that it is a bill of attainder. So, hindi pa umaabot sa ganung mga tanong. Most of the questions were on the arguments against Section 4, Section 9, and the provisions on the detention period without warrant. Sabi ni Rose Libuan, I don't have time to watch the long argument, so thank you for the enlightenment. Sabi ni Adrian Abuhandan, I always wonder kung pwedeng matarget ang mga supporters ng mga terrorist groups dito. Ganito yun eh. They can be targeted, but no, not targeted. You can be prosecuted for supporting a terrorist group if that group has been proscribed by the Court of Appeals and you are providing material benefit to that group. So, yun. Unless you have, then again, it will go into overt acts and all of that. So, teka, sinishare ko pa pala yung ating live sa Luminous group kasi hindi ko na share kanina. Oh, don't forget to like and share and subscribe after this. So, sorry, double body. Wala kasi si Attorney Ahmed to do this right now. So, we are sharing. Ayan. Okay. Other questions po? But do you understand what went on? Ayan. Sabi ni Jumong, mahahabol pa din po ba ni Solgen sa court ang utang ng mga Lopezes kahit stop na yung House hearing? The House hearings and the Solgen's actions are not related at all. Although sometimes the Solgen can go to court and prosecute a case based on evidence that the House has discovered during their hearings. Sometimes what the House will do is they will refer to the Office of the Ombudsman for prosecution, especially if it is a criminal case. Hindi po si Solgen yan. Now, the Solicitor General can defend the state when there are actions against the government. Sabi ni Peter Parker, anong tingin ninyo sa manifestation sana ni Attorney Calida? Well, it would have been a bombshell. And it also speaks, I think that that if they file, if Solgen Calida files with the Supreme Court, I think he should file for a disciplinary action. If the lawyers were in fact there or that they had pressured the ITAS to file the petition or to sign the petition. Dalawa po ang violations dyan, violation ng Indigenous Peoples' Rights Act, taking advantage of an IP. And two, this is a lie. It becomes a lie. It's dishonest. So, I'm hoping that the Solicitor General at least asks the court to take cognizance of it, or if not, to file a disciplinary action, or recommend the filing of a disciplinary action, or for the court to find or to at least admonish the lawyers who tried to do that. Tinatanong ni Ma'am Noel Sams, may alam ka bang bansa na under challenge pa ang kanilang ATL? Right now, hindi po. But I'm sure there are. We're not the only ones who do that. Pero usually, they challenge it kapag meron nang nangyari. Tinatanong ni Cite Padilla, is the soldier not allowed to speak during the oral arguments? He's asked his own questions later on, after the petitioners have been fully questioned by the justices. Sabi ni Lenny Fermin, terrorism affects both public safety and health, especially if biological weapons are used, right? Oh, even radioactive weapons, chemical weapons. May bearing ba yun sa arguments kanina? Sorry, late kami. Well, there was no argument on that because I think everybody agrees that the use of nuclear weapons, chemical weapons, and all of that, these are barred by international convention and could be crimes against humanity if misused. And if it's used for the purpose of terrorism, then it's so bad that there's no question that they should be punished. Hi, si Belial, gutom na ata. The Supreme Court is not going to discuss the petition of the two ITAs. Aren't the petitioners going to be contempted for reapplying a non-substantial case? No, this is not contempt. Just the action of the court simply is to dismiss the petition. And it's not dismissed because the Solgen says that they were coerced. It's dismissed because it's premature. Most likely, but I did not see any decision. So I am guessing that the dismissal is due to the fact that it is not timely. They have to finish the case in the regional trial court so that the court makes what we call findings of fact. So that when they go up to the Supreme Court, or if they go up to the Supreme Court, then the facts have already been established by the trial court. Sabi ni Pai, she wants to see the cat and the dog. Well, Belial is a little difficult to grab right now. Medyo malayo siya. And si Yoshi is now outside. He's asked to go outside because he's makulit. This is the other cat. Hi! Who is this? Who is this? Hi. No, this is not Belial. This is Oni girl. Hi! Say hi, Oni. Oh. Okay, down. She's noisy, but she's not really down. She's noisy because she's hungry. So, ano na siya, ang bilis. Okay? Speaking of dishonesty, sabi ni Che, if ever na nakitaan na nagsisinungaling ang mga lawyers kontra ATL, may possibility ba na ma-disbar sila? Well, they're vulnerable to a disciplinary action, but somebody has to file it. And it will depend really on what the findings of the Supreme Court and the IBP will be. Material benefit ba yung paying terrorists just to leave them alone para matuloy lang business nila? For example, Smart and Globe. Ganito po kasi yun eh. Once you are made aware that it is a crime to do it, if you continue to do it regardless of the intention, kasi hindi intention ang binabara dun sa ang binabar doon sa giving material aid, no? Basta binigyan mo yung terrorist group, then that is already a crime. Diba? Lalong-lalo na, ina-announce naman kasi yung proscribed terrorist groups. In that case, it has to be a proscribed group. Ulitin ko lang itong live, sabi ni Don Ronald. Sabi ni Ma'am Emily Kurisaki, bakit ganon? Parang lawyer ng mga terrorists sina Jokno. Well, like Justice Leonen says, expressive action can be punished, but if it is a crime, it is not a crime to defend people who are accused of terrorism. Being the lawyer for criminals is not, kumbaga, hindi po nakakahawa yung pagiging kriminal. If you're the lawyer, you're not considered a criminal. So please be very careful about that. The accused are entitled to counsel. In fact, they are the most entitled to counsel because they are facing the possible loss of either life, liberty, or property. So, you should also never take it against a lawyer that he or she is representing really bad people because the lawyer assists and makes sure that the person's rights are protected, and that is the time when they most need to have their rights protected. Okay? And I know that many of you are angry at criminals. Sino bang hindi magagalit sa kriminal? But that is the demand of due process. Kailangan, pag dinala ka sa hukuman, alam mo, assisted ka by counsel, you can get the best counsel that you think you are entitled to, or provided that you can either pay for, you can afford them, or, di ba? It's not the lawyers do not acquire the sins of their clients. Please be very careful with that because you know where I came from? I'm a defense counsel primarily. Although, sometimes private prosecutor, alam mo ba dati magkalaban kami ni Attorney Darwin Cañete? I was representing an accomplice to a kidnapping. And so the prosecutor was Attorney Darwin Cañete. But we plea bargained and so we were both happy. But that doesn't mean magkaaway kami ni Attorney Darwin. I don't blame him for prosecuting my client and he doesn't blame me for defending somebody who allegedly violated the law. Diba? That's how the judicial system works. It works yung magkasalungat talaga yung dalawang sides. And the court says that kapag may two competing ideas na ganon, that's how the truth comes out. Sabi ni Ma'am Evangeline Llagas, every time may mga important issues, I'm always looking forward to your live for the purpose of discussing it. Okay, thank you, Ma'am. Do the lawyers of the NUPL, are they subjected to disbarment regarding to the ITAS? Well, if it can be proven, and I think the Solgen does have proof of that, well, evidence of that, a complaint has to be filed and that evidence attached to it with the Supreme Court. The Supreme Court will ask the IBP to investigate. It will be sent to a commissioner in the IBP for hearing, and then whatever findings, the IBP Board of Governors will either uphold or reverse and then send their findings to the Supreme Court. Can it be done? Yes, it can be done, provided somebody will file the complaint. Hi ma'am, sabi ni Roland Flores. Pai Parcon says, ay, ang ganda daw ng kitty cat. Tama po ba nakakarinig ako? Belial yung name ng cat niya. Ay, yung kanina, that was Oni. Pero the one you heard earlier was Belial. Yeah. That's Attorney Ahmed's cat. But yeah, that's Belly Cat. Mahaba pa po ang tatakbuhin ng ATL bago ito maging permanent talaga dahil sa mga nag-challenge. The law is already in effect. It is presumed valid. The petitioners are there to try to void it. But right now, it is completely enforceable. Akala kasi ng ibang tao, hindi tayo makakahinga until matapos itong kasong to. Hindi. Walang TRO eh. So, hindi tinigil yung enforcement ng batas. Tuloy-tuloy yung duties ng Anti-Terrorism Council. Tuloy-tuloy yung mga meetings nila. They can continue to set policies, continue to make investigations. They can apply for search warrants, for wiretap, and all of that. The law is in effect. The petitioners have the burden of proving that it is void. And until they can do that and the court decides with finality, it remains in effect. And for all you know, the court will most likely, the court could uphold the law. If it doesn't, some provisions might be declared unconstitutional or they can strike down the whole law. But right now, the law is in effect. Sabi ni Tatay Strauss Fernandez, nakakadismaya lang na sa dami ng cases na nakapila sa Supreme Court, this stupid petition of the wokes are taking the valuable time of the justices. Well, I agree, but that is it's the call of the times. The justices probably feel that they should decide on this immediately so no sword of Damocles is hanging over the ATC. Diba? Sabi ni Royal Alcantara, baka gusto ko pa daw ng cat, 14 po na pusa sa bahay ni mother. Actually, I'm a single cat, single dog kind of person. So right now with 2 dogs and like 3 cats, there's already too many. Kasi ako yung type na parang Harry for the longest time was an only dog. Sabi ni Jumong, di madidisbar yung NUPL, dilawan din ang IBP president. Well, I understand where you're coming from. Sabi ni Ma'am Christina sa dating live, andun yung matabang cat. Who? Tabi or Belial? Was it Belial? Yeah. Kung class lang ang live ni attorney, meron na malapit mag-graduate ng law dito, sabi ni Calvary Kane. Thank you. Kaya po pala kayo sinasabihan ng kabilang parlor na tagapagtanggol ng mga high-profile criminals, kaya si Duterte presidente nyo. Yeah. I don't mind. Ganito yun eh. The worst cases come to me or used to come to me. I don't like to accept cases now. But I consider that a trust. Diba? So, yeah. If that's what they call me, sure. Why not? Sabi ni James, ang taas ng bilihin ng karne at manok, can the government help to lower the prices of meats? Yes, with the proper policies by the Department of Agriculture. Kinig kayo sa karambola. UP Law pala si Colmy, ba't ganun siya mag-abogado? Sabi ni Jung. Parang not every Atenean lawyer is social either. So, iba-iba po. We have different personalities. There's not like, kasi naman, ang tingin ninyo sa UP, ibang planeta kami. Hindi ganun. Tao lang din po. Bakit walang share option itong live streaming? Kasi I think you should, meron pong share option. Baka hindi ka naka-sign in. You have to sign in po to share. Sino po ang umangat ngayon sa mga petitioners at laging nasusunog sa mga justices? It's not a race and it's not a game. Like I said, hindi ito yung kampihan, kami sa petitioner tapos yay, parang tennis match, batuhan ng ano. Hindi eh. So oral argument to the Supreme Court, what you're doing is you're defending your case. And it's each cause that the lawyers defend. So kung kunwari, naka-assign kay Attorney Jokno yung Section 4 nga. So yun yung kailangan niyang i-defend. And he's not defending it against the respondent Solicitor General. In oral argument, you're there to clarify with the justices. And in doing so, to convince them of the merits of your case. So hindi ito it's not like in the trial court. You're up against each other, prosecutor versus defense counsel in a criminal case. So yun talaga, you're against not each person but against each other's case. So you can't look at it like it's it's like a basketball game. During oral arguments, you are there to present the best and to shine the best possible light on your case. Sabi ni Ophir yan, if a person unintentionally infects as many people as he could, meron ng you're already contradicting yourself. Intentionally infects as many people as he could, will it constitute an act of terrorism? Look at the intentions of Section 4. Are you trying to are you trying to bring down the government? Are you compelling the government to do something? What is the intent here? So, remember biological warfare. Pero how are you, trying to infect other people? So, let's say you set off a biogas bomb somewhere so that a lot of people will get sick. Like if there's a manufactured virus and you put it in a bomb and it infects a lot of people. And yes, that certainly constitutes an act of terrorism. Sabi ni Juliet, pero si Jokno puro naman I am unaware. Well, yeah. Pero it might be because he really doesn't know those points that were raised by the justices, and that happens. Sabi ni Kilay Problems, na parati kong naiisip sa mga defense lawyers, ginagawa lang nilang dapat para ipagtanggol yung client nila. I mean, what if ako yung walang sala, di ba? Hey, kailangan ko ng defense lawyer. That's it, exactly it. Although, there are times when like dati, magkalaban kami ni Attorney Percy Acosta. We're not enemies. We actually like each other. Pero magkalaban kami dun sa isang kaso. Remember yung road rage victim? But we eventually had to pass it on to another lawyer. Oops. Ayan. So, kami lawyers, we don't take it personally. I'm friends with a lot of prosecutors and ang natatakot sa akin yung mga if ang pinoprosecute dito or kino-cross-examine ko during the defense of my client is a police officer. There was a time na the moment I would stand up, ayaw na ng police. There was a time. I can't wait to get back to the courtroom. Will CSAFP give consideration to Parlade's statements regarding two ITAS revelations that they allegedly abused? Now Supreme Court junks their pseudo petition. Okay, first of all, the CS is not going to do the investigation. He is giving it to another body in the AFP to do that. So, and the CS will be kept out of it. He is not to be part of that investigation. Remember that General Parlade and General Sobehana have two different jobs to do. They're both part of the AFP. The CSAFP is to lead the AFP and to protect it and to look at it as an entire institution. General Parlade has a very specific job to go after the communist terrorist groups and to do that in many ways, not just combat but even in the battle for hearts and minds. Okay? So those two generals, sometimes as a leader, you will be tasked to either discipline your people or to stand by him, and the circumstances will dictate what you have to do. So in the case of General Sobehana, he is now providing a platform for General Parlade in order to be able to defend himself. Now, this what happened today can be submitted as evidence in that investigation so that the AFP has a clearer picture of what really is being argued here. We have to admit that yung mga paratang dito kay General Parlade are unusual and kumbaga lack some steps in logic. At least that is my opinion. And this goes against the opinion of some of my colleagues in the legal profession who think that the mere act of threatening to sue, if it is the anti-terrorism law, constitutes a chilling effect or endangers the reporter or things like that. But that, the fact that they have not filed an actual case for this already tells me that they're just simply here to complain about something that they, how do you call that? They can't sue. Diba? So the best thing, and since they cannot sue, there's no venue for General Parlade to defend himself. And so the CS has given him exactly that. Thank you for answering my inquiry even though I deleted it early. Sorry po, sabi ni Edgar. It's okay. Alright, since there are no more questions, thank you very much for joining the live today. Thank you for everybody who sent on the super chat. Thank you very, very much. We will be bound Karambola tomorrow. Oh, please don't forget, yun, sabi ni Ethan, I love the word heckle now, learned it from you, socialing gamitin sa discussions. Yeah, you can also use the word, our new vocabulary for today is on the Luminous page, it's cajole. Because that's yung parang kinantsawan nila to sign yung mga petitioners dito. Si attorney, layo ng pinanggalingan niya. Pirmahan niya na. That's a classic example of cajoling. So, yeah, heckle and cajole. Alright, thank you very much. We'll see you tomorrow on Karambola. Don't forget to like and share. And again, my repetitive plea, please get people to like and to follow on our Luminous page. And also, you can join the Luminous group if you, sometimes kasi you won't be able to see the page because we are being throttled, we're being restrained. Haha. You can look for the Luminous group and then apply so that you can join, and then we have good discussions there as well. If there will be times you might not see the Luminous page, put it on your favorites so you can check with us every day. Please don't leave Luminous. Please keep checking it because we will be writing a lot of discussions, especially on the ATL and when there are new laws and there are new controversies. Thank you very much. Good night, everybody. Have a good day for those who are just in their mornings or afternoons. See you tomorrow on Karambola.